I've just shared my welcome everybody. I've just shared my screen so that you can see our presentation now. Welcome to the 2022 Contra Costa Bar Association Basic Trial Skills Series. This is session 2, and we are talking about discovering depositions, the meat and potatoes of trial preparation. We have a pretty dense program for you today, so I'm going to take the questions in the Q&A box or in the chat box, and time permitting, I will interrupt and ask them as we go. But like I said, it's a pretty dense program today, so we might hold them all to the end. Our speakers today are Ashley Ayad of Chan and Punzalan. Oh my gosh, Ashley, how do you say that?
It's Punzalan.
Punzalan. Okay, Dean Christopherson of Dawe Christoph. Oh my goodness, Christopherson, and Andrew Oberst of Brothers Smith. These are our litigation experts, and they'll have quite a grasp of discovery. Beyond that, I'm going to let them introduce themselves to you.
Well, since my topic comes first, I guess I'll jump in and get things going, if that's okay. I'm Dean Christopherson. I'm a partner, as Jaime said, at Dawe Christopherson here in Walnut Creek. My background, just in a sentence, is for 36 years now, I've been a commercial litigator and trial attorney, and sort of moving into more of a practice involving ADR at this point. Shall we introduce everybody up front, Jaime, or do you want me to just dive right in?
Why don't you just dive right in, and as you guys speak, the first time you speak, why don't you give a little rundown of who you are?
Great.
Here we go.
All right. So some of this may be a little bit of review for those of you that have been at this for a bit, but sort of at the top, I just wanted to sort of give an airplane view of what discovery is and sort of how things will all fit together during the course of the program today. So as I trust most of you know, discovery is the process in civil litigation by which a party is enabled to get information from their opponent to determine the relative strengths and weaknesses of their cases and the positions within their cases. And it's done in a variety of ways and through a variety of mechanisms. And we'll be talking about each of those during the course of the program today. Some of the most common are written discovery mechanisms, interrogatories, which are written questions that you send out and get written responses back under oath. A document request, which is just what it sounds like. You can send out requests for admissions of either fact or genuineness of documents. And then there are sort of other types of discovery that sort of aren't really circumscribed by just being written discovery. There you can do an independent medical exam, or what we call an IME. I think Ashley's going to be talking about that after a bit, where you can, if there's a PI component or a medical component to your case, you can have someone evaluated by your own doctor. There's expert discovery that usually happens at the end of the case. And then for a reason that escapes me, I didn't put depositions on here. Obviously there are depositions, and I'll be talking about that in depth later on during the course of the program. So Jaime, if you can get me to the next slide, that'd be great. So to put this all in some sort of context, we need to think about what is discoverable and for what purposes discovery or what type of information discovery can seek. And the general concept is it's about as broad as it can be. The general rule that I learned when I was a young litigator is it needs to be something that's reasonably calculated to lead the discovery of admissible evidence. And so what that means is it doesn't need to be something that you're going to actually necessarily need to use during the course of your case in the presentation of a motion or to put on a trial. It could be information that would lead you to something else. The sorts of things that might be are, where are bank accounts located, so that you can gather financial information or look at what transactions look like, but you need to first know where to look. It might be how somebody's computer network is organized or what their backup structure looks like, so that you can know, what sort of data is maintained and how, and that allows you to fashion more pointed and focused discovery in your second round. So it doesn't have to be something that itself is admissible. It can be something that sort of takes you down the line toward information that is going to be what you ultimately need in order to prove up your case or to disprove the other side's case. And you get people who during the course of discovery want to make relevance objections. They're not very often well taken, just because discovery is so broadly construed and allowed. And another example of sort of what is discoverable or what types of things fall within the ambit of discoverable information is in this little snippet that I put up from Lopez versus Watchtower, which really focuses on what its ultimate use might be. So if it's going to be helpful in evaluating the case and preparing for trial, or even in facilitating settlement, which is something that you don't really think about in the context of discovery often, it can be discoverable information. I want to just talk then briefly about kind of when discovery can be taken. And generally speaking, at the very outset of a case, there's a stay on discovery for the plaintiffs. It's 10 days after service for written discovery and 20 days after service of the complaint for depositions. There is no comparable stay for defendants. As soon as they get served, they're welcome to go ahead and start up the discovery process right away. On the other end of the case, you've got the discovery cutoff, and the statutory rule really is that discovery cuts off 30 days before the first date that's set for trial. So if you're in a situation where you've got a trial date set and then you get it continued, unless the court orders otherwise, your discovery cutoff still falls on the 30th day before the first time your case is set for trial. So if you've got a continuance and you're concerned about being able to finish discovery, if you're at a trial setting conference or whatever, raise that with your judge so that that's made clear in the trial setting order. The course of what we're talking about today really focuses on discovery in state court. But I wanted to give one little nod to sort of a different twist on discovery in federal court for those of you that may wander in that direction once in a while. And that is, in federal court, right at the very beginning of the case, there's an obligation to provide what are called initial disclosures. Those are usually, the timeline for that's usually set in the court scheduling order that comes out at the beginning of the case. And it's a pretty onerous obligation that's placed on the parties, because you need to gather up and produce all the documents that you know of that are relevant to the case. You need to identify all the witnesses, including their contact information that you know that are going to be helpful or unhelpful. And when you're a plaintiff, you have to provide damage calculation information so that the other side can understand what it is you're seeking. So as I said, going forward, we're really going to be talking mostly about discovery in the state court context, but that was just a little caveat that I wanted to carve out there for those of you that get into federal court. So that's kind of my initial table setting. And at this point, I think I'm turning it over to Drew to talk about interrogatories.
Yeah, my name's Andrew, but you call me Drew Oberst. I'm an associate at Brothers Smith LLP in Walnut Creek. I handle business and real estate litigation and transactions. Before doing that, I was a litigator with a local firm of Contra Costa County in Solano County, where I did personal injury defense for about 5 years, second chaired 2 trials, worked on some appeals, various stuff. But basically, I'm going to give, you guys can look to the practice guides for some of this information. I like to give a lot of practical advice when I tell new attorneys things. So sometimes I'll be applying some of those to some of the stuff Dean goes over and some of the stuff Ashley goes over in my presentation. So like Dean mentioned, interrogatories are written questions sent to one another by that are answered under oath by the parties. More specifically, form interrogatories are drafted by the Judicial Council of California and pertain to various aspects of litigation. So you have DISC 001, which is a Judicial Council form for general interrogatories for personal injury and damages. You have others for employment law, unlawful detainer, limited civil cases, and then construction litigation. Basically, it's a form, check the boxes, send it with a proof of service to the other side, get your answers of who, what, when, where, why. kind of gets the ball rolling on litigation, as we normally say. One of the tips that I wanted to add about written discovery is, like Dean mentioned, answered under oath under penalty of perjury. As you learn to do this, make sure you learn how to use written discovery responses in deposition. Make sure you can confront your witness, present them with their discovery responses, get those answers, narrow down the issues, make them commit to their answers in written discovery. It'll really narrow the issues for you in the long run, especially if you're going to trial, or if you expect a case to settle. You can really lock people in to their answers under written discovery. So learn the applicability of when to use written discovery. The other thing is the practical matters of limited civil discovery. I want to mention that especially. When you're a hungry young attorney, you're going to take cases that aren't multi-million-dollar cases. They're going to be limited to, $25,000. In those cases, you're limited to 35 interrogatories, requests for admissions, requests for reduction of documents, and form interrogatories. So that's a total of 35. So 10 form interrogatories, 10 special interrogatories, 10 requests for production of documents, and maybe 5 requests for admissions. So keep that in mind when you're preparing in limited civil cases. Go to the next slide, please, Jamie. Request for admissions is another issue I'm going to hit pretty big. This is really important in litigation. It's one of the most powerful written discovery tools out there. Most discovery procedures are aimed at narrowing, issues of facts, what, when, where, why, how. Requests for admissions are aimed at setting aside triable issues. These can be legal issues, factual issues, and the authenticity of documents. In my opinion, requests for admissions are more akin to using summary judgment in discovery. Basically, response to requests for admissions are more powerful than a deposition or written discovery. The key is that once they're answered, they can't be amended without leave of court. Responses in deposition and written discovery, they can be waffled, they can be changed somewhat, or in approaching trial, when you request supplemental responses, which will be covered later, they can amend their responses. Requests for admissions don't work like that. Once somebody has answered them, they're locked in. That's why it's really important to follow up, especially in these responses. A lot of times people will waffle and give you responses like, oh, calls for a legal conclusion, which is not a valid objection. Or they will say, they will try and put you off and not answer the question, or not answer the admission. You've got to follow up with these. This is one of the most powerful tools in discovery, and people know, and seasoned attorneys know this. So they will try and avoid it. They will try and push it back. There is an escape mechanism of you don't have enough information to answer the question at the time, but follow up, people. You get 2 supplementals before you set trial and 1 after. So make sure you follow up. The other thing is it goes back to objections that Dean mentioned. Know what objections are applicable and which ones are not in requests for admissions. A lot of attorneys will try and use the calls for legal conclusion. That's not a valid objection under the law. I've won multiple motions in many courts in California that state that you cannot do that. And I've actually gotten sanctions against the other side for doing that. They'll hide behind that objection. It's not a valid objection. Next slide, please. Next off, there's form interrogatory 17.1, which when combined with requests for admissions creates what we call contention interrogatories. So if the party does not admit the request for admission and they either deny or don't flat out answer it, you can serve this with it, and it requires them to state all facts, witnesses, and documents to support that the lack of that admission, or that they're going to contend that fact at trial. Very powerful discovery tool. Always consider serving 17.1 with requests for admissions, because you get the additional contention interrogatories, which I'll go over now in phrasing requests for admissions. Next slide. When phrasing requests for admissions, look to your complaint if you're a defendant. Look to the answer if you're a plaintiff, right? You want to look to the Casey instructions also to look at those causes of action that are being alleged, and look at those elements like what you learned in law school, and take each one of those elements or each one of those facts and try and put it into a single request for admission. It becomes a very powerful tool that the opposing party has to support their contention. And it really straightforward puts the ball in their court that they have to explain to you the information, or that they're going to be denied at trial of being able to seek that relief. Contention interrogatory is very, very similar to that 17.1 I pointed out, which actually will get more into special interrogatories. List all facts, documents, and persons. Again, look to your complaint, look to your answer, and look to the KC instructions. If you form those contention interrogatories along with requests for admissions, they can be a very powerful settlement tool and a very powerful tool in preparing for trial. Next slide, please. And then I'll just give you the timing of these. It's highly dependent on whether you're not a plaintiff or you're a defendant. Timing for requests for admissions, especially on a plaintiff side, you're going to want to find out early on whether or not a defendant is going to contest liability. So if they are going to make a claim of comparative negligence, or if maybe the plaintiff has a pre-existing condition or something like that in a personal injury matter. You want to get that out of the way as a plaintiff's attorney, because you're not going to want to retain all these experts, or you may need to retain these experts based on what the contentions of the defendant are. Now, a defendant, on the other hand, may have to wait this out a little bit further, because they may need to get more information to see what's going to be brought at trial, and you want to get those out of the way before commencing with expert discovery, which we'll get into in another topic. Next slide, please. One more. And then I'll just give you my general tips to live by in litigation. Know thy deadlines, people. Learn that responses are due within 30 days plus whatever the service mode is. Learn that 45 days for a motion to compel upon verified discovery. The last day to object before deposition. Learn the tricks of 100 days before trial. Know your expert demand dates, and especially know your expert disclosure dates. You got to learn those specific rules in litigation. These are just general cleanups that, like I said, I give practical advice. One of the biggest causes of malpractice claims remains missing a calendar deadline. So you have to know deadlines as a litigator. It's one of the most important things that will give you the upper hand on the other side. The other thing too, objections and legal authority, especially in discovery. Practical advice, don't reinvent the wheel every time you're responding to discovery or doing what we call meet and confer when you think somebody hasn't met their discovery obligations. Create an armory of case law, facts, law, and other aspects in a document or something like that for each section that you can use and can be your go-to of when somebody makes a particular objection or when they're trying to conceal something or avoid their discovery obligations. It will save you a ton of time in the long run. That is, I mean, it really will save you a ton of time. Also, tentative rulings. I just came up with this. If you get a tentative ruling in your favor, look at the case law in it, save it. I'm telling you, you'll want it again later, and it'll be practical in other motions and other aspects of discovery. And then I'll pass it to Ashley.
Hi, I'm Ashley. I'm an associate at Chan and Punzalan. I currently do business litigation. Previously, I was in insurance defense. So that's a bit of my history. So I'm going to be talking a little bit now about special interrogatories. So these are a little bit different than form interrogatories, which is sort of a list of questions that the court has approved. Special interrogatories are written questions that are prepared by one party that are specific to the claims being made in the case. Because it's not a form, it's on typical pleading paper. There's an identification section, sort of who's the propounding party, who's the responding party. When you're propounding special interrogatories, a lot of, I mean, I've never not seen definitions in there. You want to make sure that your definitions are as clear as possible and unambiguous. When you draft discovery requests, always try to make sure that you're drafting it in a way that will lead to the least amount of objections possible, because you just sort of don't want to necessarily have that fight later on if you don't have to. Considerations when propounding special interrogatories: each party can only propound 35 special interrogatories. If you want to propound more, you have to attach what's called a declaration for additional discovery. It just looks like any typical declaration that you would draft. And it states sort of the good cause reason that you have for needing more interrogatories. When drafting special interrogatories, it's also important to remember no subparts are allowed because of this 35 interrogatory limit. So you can't try to ask about multiple topics in a single interrogatory. You want to limit it to one topic and try not to ask two questions in one. That doesn't mean that every time you see an "and" in the question, it's considered two different questions. Just something to be aware of. Let's see here. Can we go to the next slide, please? So when responding to special interrogatories, each party must provide answers and/or objections. There is a duty to answer completely and fully with the information that is currently available. And there is also a duty to obtain that information. Just because it's not immediately available does not mean that the party does not have access to that information. And so long as that information is accessible, you have a duty to go out and search for it. As for objections, Andrew sort of touched on this. There are certain objections that you can make that are proper, and then there are some that are just not allowed for special interrogatories. Typically, you can't, or not typically, you can't just create general objections to an entire set of interrogatories. You have to specifically object to each one. And just try to make sure that you're staying away from boilerplate objections. The objections need to actually apply to the interrogatory being requested. So some improper objections that I've seen are, calls for a legal opinion, assumes facts not in evidence. Some of these objections might work in a deposition, but do not work for written discovery. Proper objections include things like relevance, for example, but I would caution the standard for what is relevant is something that can lead to admissible evidence later. It does not necessarily need to be admissible in terms of the response for it to still be relevant. Other objections that are sort of not the best, vague and ambiguous, unless the request is so unintelligible that the vague and ambiguous objection typically doesn't hold. Verifications are also required for special interrogatories. If you don't verify the responses, it's the same as almost not responding at all. There is also no duty to supplement your responses if you learn about information after responding. However, actually, can we go to the next slide, please? And this gets to supplemental responses. Although there is no duty to supplement responses, the propounding party can serve supplemental interrogatories later on to ensure that responses are still accurate and current. You can serve supplemental interrogatories about, I think, 3 times, twice before trial is set and then once after, but before the discovery cutoff. Typically, the substance of supplemental interrogatories would sound something like, please review your responses to interrogatories propounded previously. And if for any reason any answer is no longer correct and complete, please identify the answer and whatever information is necessary to make that response complete as of the date. So these are really great to use sort of when you believe that there is more information now that discovery has been ongoing for some time, and you want to make sure that the responses that you previously obtained are still current. Can we go to the next slide, please? So now we'll talk about requests for production of documents. These are another form of written discovery that you can use to inspect and review documents that the other party might have. There is no limit on how many requests you can propound. So typically when propounding requests for production of documents, you want to make sure that the time and place for producing the documents is stated in the demand. And usually that date should be 30 days after service of the demand. When drafting these requests, you should identify the subject matter of the request as narrowly as possible. So consider limiting the scope to, non-privileged documents. Try to limit the scope of the request to certain dates if you can. Try to avoid language like all documents referring, relating, evidencing, whatever the thing is, and instead maybe documents sufficient to show something. And you also want to make sure that when you're saying, you want to try to narrow the category of documents that you're looking for. So instead of all documents showing the personal injury claim that the plaintiff is making, maybe ask for records from the specific doctor. So instead of all documents, it's really specific to the kinds of documents you're looking for. If you're trying to discover electronically stored information, when creating the demand, make sure that you specify how you want to receive that electronically stored information. If you don't, it's sort of up to the responding party how they want to serve it. So in terms of the form that you want it in, specify whether you want it in native format, if PDF is fine, or if you're looking for TIFF files, that kind of thing, you want to make sure that you specify. Sometimes native format is what you want to go for. If you're looking for things like metadata of the documents, it sort of depends on the case. Can we go to the next slide, please? And when responding to requests for production of documents, the response to each request needs to either state whether or not the party is going to comply with the request, or a representation of their inability to was made, or you respond with objections. The format of production, so documents need to be sorted and labeled to correspond with the categories in the demand. As I mentioned earlier, if the requests are looking for electronically stored information, but it doesn't specify the format,
Hey, Ashley, I think we're losing your audio.
Nope. Let's go ahead and go on to the next slide, and then we'll come back if we gain Ashley's audio. Ashley, why don't you try to sign off and rejoin while we move on? Andrew or Dean, let me know who's up next, and when you get to a slide, that'll work. And then we'll return to Ashley's slide.
I'm happy to go to pick up. I'm on slide 22, Jamie.
There we go.
There we go. Okay. Sorry about that, folks. So one of the things that we wanted to alert everybody to, particularly when you're practicing before our court here, is that there was a new program that was initiated, geez, I don't know, 10 or 15 years ago now, probably, that deals with the resolution of discovery disputes in cases pending in Contra Costa. And basically what it does is it creates a program for attorney evaluation of disputes independent of the court before a motion to compel can be filed with the court. And it is a program, the rules for which are codified in the local rules here at Rule 3.300 and 3.301. So it's important for you to know that where to find that and what to look for there. But generally speaking, if you're a party who's propounded discovery and gotten the answers that you don't like, and you've gone through your meet and confer process, this is the next step that you need to take before you can address the matter to the court. So the process goes like this. You fill out a form that's available on the court's website, asking for the initiation of a discovery facilitation, and you email that to the court's ADR department. So you don't have to file it, you can just email it in. The email address for the department is listed in the local rules. What happens next is that the ADR clerk will appoint an attorney who's on the panel to hear the dispute. And a notice is sent out to all the parties providing information about who she or he is. The court gives a pretty good deal of leeway to the facilitator that's appointed to determine how they want to actually go about the facilitation process. In the facilitations that I've had, I try to run them kind of more like a mini motion to compel rather than some people handle them more like a mediation where they try to get people to come to an agreed resolution of the dispute. But as I said, it's really up to the person who's handling the facilitation to sort of set the rules and to shepherd the matter along through to a resolution. Ultimately, there will either be, there's generally one of two things that is the outcome of the process. One is a document that's filed by the facilitator with the ADR department indicating that the dispute has been resolved. Or the second alternative is there's a report that's filed with the ADR department with the recommended disposition of the dispute. And the party against which the facilitation was brought can either comply with that or not. But if they choose not to, the party who brought the facilitation proceeding attaches that document to their notice of motion to compel, and that's sort of their ticket to have the matter heard by the court. There are a couple of things that are sort of traps for the unwary here. I mean, one is you got to know this exists, because if you don't and you go to file your motion to compel without having checked this box, the court's not going to accept it. And if you're right up against the deadline, you could have a problem on your hands.
And Dean, we have a question. Someone's asking if you know if the Discovery Facilitator program applies to family law cases.
I don't think it does. I think it's just probate and civil. All the ones I've ever handled are civil, and I think that's the rule. But you can check it. It's going to be in 3.300 in the local rules. The other thing that I wanted to mention with respect to this kind of a program is that many of the courts that you're going to be venued in throughout California have programs that are like this, and it may not mirror this exactly, but always check the court's local rules before you get to a point where you're running up against a deadline for a discovery dispute. Some courts have a process where there'll be an informal conference with your trial judge or your all-purpose judge that'll be done on a conference call or by court call informally to try and get the thing resolved beforehand. But again, just know what the procedures are in the court in which your case is pending. So that's my bit there. Do we have, look, we don't have Ashley back. Shall I proceed, Jamie?
Yes, why don't you proceed?
Okay, you want to give me my next slide then?
Yep.
Thanks. All right, so I'm going to spend a few moments now just talking about depositions, which in my practice have sort of been the most productive means by which to gather information from the opposing party. They're really the only chance that counsel has to talk directly to their party opponent. And it's a pretty powerful tool because you don't go through the filter of their lawyer in getting the answers to your questions. So unlike interrogatories where you ask a formal question and you get an answer back that's not drafted by the party, but it's drafted by the lawyer, here you get to talk to the defendant or the plaintiff, as the case may be, or the third party directly. And so you not only get the information that you're looking for in sort of an unfiltered way, but you also get an opportunity to evaluate that person, their credibility, their demeanor, just the way they're going to present once they're on the stand if you have to try this case. So you just get a whole lot of information from taking the deposition of particularly your party opponent. Like the rest of the discovery processes we've talked about, this is a process that's handled under oath. So there's really not a lot of wiggle room once they give you an answer. So just to tick some sort of logistical boxes here, you can take a deposition of virtually anyone so long as you can get jurisdiction over them. It's easy to take the deposition of a party, either an individual or a corporate party. All you have to do there is serve a notice of deposition on the counsel that's representing the party, stating where and when the deposition is going to occur and identifying the party. If it's an individual, it's just their name. If it's a corporation or other entity defendant, you name the corporation, but then you also have to identify the topics on which you want to take testimony. And sometimes those can be pretty lengthy topics, and sometimes that will require that the entity defendant put up more than one person to provide testimony, because, for instance, if you want to take a deposition on financial issues, that might be one person, and if it's IT issues, it might be another person, and if it's your liability issues, it may be somebody altogether different. If it's a non-party, it's a whole different process. You have to serve them with a subpoena, which is a judicial counsel form. Be careful which subpoena you use, because there are, half a dozen different subpoenas that are used for different purposes. But you want to use a deposition subpoena. There's one that also can require that documents be produced. And it needs to be personally served by a process server on the person that you want to have to come and testify, sort of using the same rules for service that you would use if you were serving a summons and complaint. Generally, there's 10 days, a minimum of 10 days notice if you want a deposition that's just testimony, more time if it's going to be production of documents as well. And Ashley was going to talk about the provisions of Code of Civil Procedure section 1987.3. It's a typo. I have 1985.3, which provides for a notice to consumers if you're looking for information that is, either healthcare related or financial related. Generally, you have to send out notice to anybody whose information you're trying to gather, and you have to serve that on them before you serve the subpoena. So just we could go into that for quite some period of time, but just be mindful that there's another whole sort of overlying set of requirements that are imposed on you if you're trying to get information regarding what's defined as a consumer under that section. In the world where we're practicing now, where depositions are taken generally by Zoom, the distance location or the distance requirements aren't really as applicable as they used to be. It used to be that you could generally only require somebody to travel 75 miles either from their home or their principal place of business to take their deposition. Now that we're doing it by Zoom, kind of all of that is out the window because they do it from their kitchen table. But if you do need to take a deposition where somebody's going to appear in person, be mindful of that. The people who can attend a deposition, it's generally sort of commonsensical. I mean, obviously the deponent and the counsel that's taking the deposition, but also counsel for any other parties, whether they're, a cross defendant or a co-defendant or whatever, also are welcome to appear. So the counsel and all parties, but third parties can't appear absent a stipulation by the parties. So the only exception to that may be if you've got a consultant that is going to come in with counsel. That doesn't happen too often, but even in that situation, probably best to alert opposing counsel that that's going to happen. And depositions, it's sort of how high is up with corporate depositions. They can go on and on depending on how many topics you have for the PMQ. Individual depositions are limited to 7 hours by statute. Many of them take much less time depending on how focused or how extensive the topics are you need to cover. Next slide, please. One thing that doesn't get talked about a lot in discussions of depositions is sort of how to deal with your court reporter, but that's an important thing to consider in order to have a successful deposition. Generally, the court reporter is thought of as sort of having two functions during the course of a deposition. One is at the outset of the deposition, she or he will be the person who administers the oath to the party, having them raise their hand and swear to tell the truth. And then after that, they're just sitting behind their stenography machine, taking down a transcript of everything that's said during the course of the deposition so that you can end up with a usable work product at the end of it all. So, you'll end up with the booklet. It's something that can be reviewed by the party whose deposition is being taken to make sure it's all accurate in their rules. And we could go into that for a long window of time about how that works, but know that the party has an opportunity to review it after the transcript is prepared. Just sort of some helpful tips about, making the court reporter's life easier during the deposition and therefore getting yourself a better transcript and work product. One thing that I see happen often, particularly when somebody who's taking a deposition and asking questions is anxious or nervous or unprepared, or if they're reading something into the transcript, is that they just talk too fast. And the court reporter has to tell them to slow down. And that sort of breaks up the whole train of thought. So just be mindful of that and try and just proceed at a normal pace when you're taking your deposition. Another thing that is important to be mindful of is not to speak over other people when you're talking or taking the deposition. I mean, it's not the way that we converse normally in day-to-day life, but the court reporter can only transcribe or take down what one person is saying at a time. So you have to sort of, let one person finish before the next person starts, and it's a little awkward, but try and get that ingrained into your processes for taking depositions, and things will run a lot more smoothly. A problem that I've seen come up, particularly if you're going to be taking a really lengthy deposition, is not alerting the court reporter's company that you're expecting the deposition may run long, because the last thing you want to have happen, particularly if you're taking a PMQ deposition, is it's 4 o'clock and the court reporter says, "Counsel, how long are you going to go?" And you say, "Well, I wasn't expecting this, but I think I've got 3 more hours." And they say, "I've got a child to pick up in 30 minutes. So you need to be sure that you give heads up if you're going to be running into a situation like that, so that you don't end up with a problem. And the final thing is just sort of common sense. Make sure you're mindful of when the court reporter needs a break, because while we're sitting there and we're all engulfed in the nuance of what's going on, the case to them is just no different than the case they heard yesterday or the one they're going to hear tomorrow. They're not enthralled by your questions. They're trying to keep up, and it's just if there's not a break every hour and a half or 2 hours, ask them if they need a break, and they'll love you for it. Another option that you have when you go to take a deposition is determining whether or not you want the deposition to be videotaped, which was a whole other process before we again were in the world of Zoom. Taking a videotape deposition is considerably more expensive than taking just a regular deposition with a stenographer, probably by a factor of 2 or 3. So be mindful of that when you're budgeting. But they can be very impactful if they're used properly, and particularly if it's a case that you expect to be going to trial. But it can be, you need to have somebody with a technological savvy to put them on a trial and have your testimony. There's a process to link the testimony so it shows in the screen. Anyway, a lot to do if you're going to use video testimony at trial. But sort of a thought about when it makes sense to use it is, in my experience, and I don't know what the others would say, but if you've got a witness that you think is going to be a problem, or belligerent, or even counsel that's going to be troublesome, the fact that a camera is running sometimes kind of calms people down and makes them act, in a way that it has a little more demeanor behind it. Okay, how are we doing for time, Jamie? Do we need to go back to Ashley?
I think that we're doing okay. Yeah, let's try to go back to Ashley, and I'll see if I can get my PowerPoints to go backwards here.
Okay.
Okay. My PowerPoint presentation is frozen. My goodness. Technical difficulty. I'm going to try to go back.
Try unsharing and then sharing again. Oh, there you go.
Are you good? Ashley, is this a good place to start? I don't know if we've got your audio back. Nothing from Ashley?
Ashley, did you log off and log back in again? Can't hear you, so.
So why don't I finish up my last slide then, Jamie?
Yeah.
All right. all the
Ashley,
way
just
back.
log all the way out and log all the way back in again. Thank you.
All right.
Is this it?
Yep, that's it. So, sort of the payoff for the whole deposition topic is sort of how to go about it as the attorney that's asking the questions. And rule 1, 2, and 3, I think, is just to be as organized as you can be. My practice is to always prepare a script of questions to use as a guideline, not as something I'm going to read. But the process of preparing a script really forces me to organize my thoughts and sort of get the topics organized in a way that makes sense. And I always do it on a computer so I can move things around if I need to in an easy way. And as a rule of thumb, I would say plan on spending about as much time preparing for the deposition as you plan on taking it. So, it's not something that you want to just rush into without giving it a good bit of thought. At the beginning of the deposition, there's sort of a set of standard admonitions and instructions to the witness that you'll learn that, after a while are just sort of, roll off your tongue. And some of them are the things that I was just describing when we were talking about ways to help the court reporter. Don't talk when I'm talking. I'll try and wait and ask my question when you're finished with your answer. Refer to exhibits by the numbers, not by the descriptions. Let me know if you don't understand the question that I'm asking. Otherwise, I'll presume that you understand it. I mean, there's all kinds of things like that. But once you get them down, you can just kind of copy them over from one script into the next. Another thought is to try and have ahead of time, perhaps, a protocol figured out with your opposing counsel about how you're going to handle exhibits. I find that particularly if you've got a case that you think is going to be tried, it's best to just run exhibits sequentially, starting with exhibit 1 in your first deposition and ending up with the last exhibit number at the end of your last exhibit, so that the same document is always referred to by the same exhibit number throughout all your depositions. And that way, when it comes time to have trial, you're not saying, well, exhibit 3 in my trial binder is actually exhibit H in the deposition of Mr. Smith. and it was Exhibit 3 in the deposition of Ms. Jones, it's always Exhibit 3. And it just makes everything a whole lot easier if you do it in that kind of a sequence. The last thing that I would say about depositions is just try not to let objections throw you off. You know, one of the admonitions that I always give when I'm taking a deposition is, you know, you'll hear objections during the course of the deposition. That doesn't excuse your obligation to provide me with an answer. So if I get an objection, I'll hear it, and then I'll turn back to the witness and go, may I please have an answer? Don't get caught up in an argument with opposing counsel. It'll just kind of throw you off your game. The only exception to the obligation of the witness to answer after an objection is when a witness's counsel gives an instruction not to answer. This is something that's done far too often, and often in inappropriate ways. The only place where this is really appropriately used is where there's an objection, where if an answer is given, it's a bell that can't be unrung or toothpaste that can't be put back in the tube. And those are things like asking for privileged information, asking for information subject to the right of privacy, asking for trade secret information or work product. So if you get an objection and an instruction not to answer, usually what you want to do is ask the court reporter to mark the question, and then that'll give you a signal where to go back to, so you can consider after it's all done whether you want to move to compel a further response. And my last bit of advice is, if you're defending the deposition, don't over object. You know, people always feel like that when they're sitting there, they want to be sort of earning their keep and saying something. And there's just not that many situations during the course of a deposition where an objection is really, really necessary. So just be judicious with that. So that's my conclusion. I don't know if we've got Ashley back ready to go, but thank you for your attention.
Ashley, could you try to turn on your audio once again, and we'll get back to
Yeah.
your slides. There we go. We hear you now.
Can you hear me? Oh, awesome. Okay.
Yes. All right. Subpoena.
Yeah, so I'll just try to get through this as quickly as I can. Deposition subpoenas can also be used to request business records from businesses or third parties that aren't parties of the case. A deposition subpoena needs to be served on all attorneys of record, and they need to be given an opportunity to purchase a copy of the documents being produced. Can we go to the next slide, please? So this was briefly touched on. When subpoenaing consumer records, so these are records from like telephone companies, banks, financial services, or healthcare providers, stuff like that, you need to serve what's called a notice to consumer prior to serving the deposition notice. And the notice to consumer goes to the consumer of whom the records are being sought. And so sort of just advises that these records are being sought and that the consumer has a right to object. Typically you serve these at least 10 days before serving the deposition subpoena. The last thing on third-party subpoenas is that the motion to compel deadline is 20 days after service of any written objections that might be made to the deposition subpoena. Can we go to the next slide? All right, so independent medical exams. So these exist in personal injury cases. The defendant has a right to one physical exam of the plaintiff. This doesn't include mental exams. It's limited to whatever portion of the plaintiff's body that are in controversy in the lawsuit. It's important that the examination place is within 75 miles of the residence of the examinee. Can we go to the next slide? So after being served with a demand for IME, the plaintiff has 20 days to respond. When the IME actually takes place, plaintiff's counsel can be present to observe the actual exam as it goes on. They're also able to record the examination, but it's limited to audio. Defendant is also obligated to produce the IME report after the medical expert writes the report and sends it off to the defendant. It's important to remember that any communication with an expert can be discoverable. So when talking to the expert, just try to make sure you do it over the phone. It's all verbal. Anything that you want to sort of keep to yourself, don't put that down in writing. Can we go to the next slide, please? So expert witness exchanges. So the deadline for the demand for expert witness is 10 days after the trial date is set or 70 days before the trial date, whichever is closer to the trial date. Expert witness data must be exchanged no later than 50 days before the initial trial date or 20 days after service of the demand. Again, whichever is closer to the trial date. Can we go to the next slide, please? So in the, when actually exchanging the list of information, the list needs to set forth the name and address of each person whose expert opinion that party expects to offer at trial. Keep in mind, you should check the local rules regarding this because some courts do limit the number of experts that you're allowed to sort of use and disclose. If an expert being listed is a party to the action, an employee of the party, or was retained by a party for the purpose of forming or expressing an opinion, an expert witness declaration needs to be included within that expert exchange. The declaration usually contains sort of the qualifications of the expert, the general substance of the expected testimony, and that the expert is ready to testify. And where an expert was retained, costs and fees should also be included. It's really important to make sure that you are including all of the information that is required, because the effect of not including everything that is required could result in exclusion of that expert's testimony at trial. And I think that was it for me.
Yes, we've gotten to the end of your slides. So I don't have any questions in chat, and I think we're just a couple minutes over anyway. So thank you to all of our speakers, and thank you for our attendees for spending the evening with us. And do you want to say a thank you to our sponsor?
Yes, I just wanted to let everyone know that our sponsor for this series is iPro. They'll be on next time to give you some information about the products that they have. They work with Trial Director, and that's one of the trial basics we're going to be exploring in June. So we wanted to have them along for the ride with this series. Again, the barrister section, wanted to let you guys know the barrister section is having a meeting on the 18th of January. They're trying to reinvigorate their section, and they're looking for board members and people who want to get into leadership. So they're looking for any and everyone to attend the meeting and be part of that. So if you're a barrister on this event, please feel free to join in.